what they're going through. I don't think they're going to do that kind of data from them, but they're going to be able to get the data from who they've been talking to, what have they been saying, all that kind of stuff. And so the communication here is about the data that they've collected, and then there's some dispute on them actually turning it over. So this is going to be coming from, thank you for your time to discuss. So I believe this is from the WFG side to Olson side. So WFG is writing this, basically, the lawyers on WFG side. So they're saying, thank you for your time in discussing the status of the document collection efforts, as well as to meet and confer with your responses to the plaintiff discovery requests. Although the court ordered your clients to respond to the discovery request within 5 days, so they should have already gotten all of this information. To date, neither Mr. Olson or Mrs. Olson nor GFI have produced any documents. So this is back on the 7th? Yeah, they sent this on the 7th. So it's been weeks since then, and they still haven't gotten the information. Into the response requested, they're requesting additional time to complete their responses based on the estimated volume of data and documents that you have collected and review in order to respond to limited early discovery requests served by WFG. With respect to your collection efforts, we understand that such efforts are ongoing and that you are searching through both Sandra and Eric's phones, including GroupMe, Signal, Telegram, their personal email addresses, as well as documentations located in the iCloud and Google Drive. We also understand that counsel for Mr. Olson is undertaking a collection of Ms. Olson's and GFI's documents. We understand that at this time, given the volume of data that you are collecting, that you are unable to determine the number of documents that are likely to be produced. You offered to provide, oops, I should turn that on. You offered to provide terms and hit counts to facilitate the parties' discussions regarding the additional time you may need to complete your responses to the request, but to date, you have not yet provided the search terms that you are using or hit counts for any of the data sources that you are collecting and you're searching, other than stating you have hits for around 2,000 emails that you are currently reviewing, and we are unable to ascertain why additional time is necessary or reasonable. Your recent statements about volume of data is required and why it necessitates additional time were unexpected given Mr. Olson's prior sworn statements to the court that he was not part of GFI during this time at WFG. So apparently, Olson's sworn statement is that he was not at GFI and WFG at the same time. You guys tell me what you think about that. Do you believe that statement? And this is where it gets into semantics, right? It's like Bill Clinton was the best at this. What is your definition of a sexual relationship, right? Like, okay, so his wife is founding GFI. They're talking to agents and recruiting them over, but was he a part of GFI, right? Like, if he's not an agent with GFI, is he actually part of GFI? And that's kind of what they're saying is, Olson is saying, well, I was never part of GFI until after I got terminated with WFG. Okay, sure. Not in possession of any WFG's confidential information downloaded before his termination from WFG. Declaration of Eric Olson in opposition to WFG's motion for temporary restraining order. However, we appreciate your efforts to conduct a fulsome collection and search for responsive materials. Secondly, we met to confer on discovery responses themselves, as we stated in our position or scope of requests of reasonable and narrowly tailored. So again, they're going through, look, we've been granted this expedited information. It's already reasonable, it's already narrowly tailored, so why aren't you turning over these documents? Despite this, you have lodged on behalf of Eric Olson 10 pages of objections to the plaintiff's 4 requests for production of documents and 10 pages of objections to the plaintiff's 4 interrogatories on behalf of Sandra, 9 pages on behalf of the 4 requests of production, and 11 pages of objections to the plaintiff for interrogatories on behalf of GFI, 13 pages of objections in response to the subpoena. So they're just delaying everything here. Like, instead of getting the data, they're objecting to all of it, even after the judge said that they should get it and they should have it. As part of your objections, you unilaterally impose additional limitations on the scope of these discovery documents, meaning you're putting your own limitations. The judge said I should get this, and you're saying I should get this, and that's not accurate. So on behalf of each of your clients, you are imposing both temporal and subject matter limitations on what you are willing to search for and produce. As we explained, we do not think that it is appropriate here, that it is our position that choosing Eric or Sandra's termination dates as the date from which you are willing to search for or produce documents is entirely inappropriate, right? When the relationship started is very important, because if you were doing things beforehand, then that's what's important. And that's what I think the judge messed up in that other case, is he said, well, from the date that they said the relationship started is when I'm going to take this information here. I'm going to throw out everything they did before that, before when he was married, before all of these things happened. I'm talking about that other one with Fannie and Wade. But all of that information is important to what's happening here. And GFI is saying, well, that shouldn't be important. It should just be from the date that I actually got terminated. So the Olson's unfair and unlawful practices began before Ms. Olson resigned from WFG. Yeah, exactly. So what were the things they did before they resigned? That's all going to be important to the court, and clearly well before Mr. Olson's agreement with WFG was terminated. Indeed, your clients even acknowledged that their frustrations at WFG and desire to establish a competing business was prompted, at least in part, by frustrations when WFG would not approve Mr. Olson's request to transfer his downline to Ms. Olson. As part of a concession to reach an agreement and to receive documents more promptly, we provide limiting the temporal scope of the production from September 2023 to the present. So they're saying we don't even need before that. There's probably stuff that was happening before that, and they can go back and request it if they need. But they said, let's just start with the date of September. You're right. We don't need to do all of 2023. That's probably too much information. Just give us from September to the present. Based on that same information, Mr. Olson declares, as well as the limited information that is publicly available to GFI, which makes it clear it was established in early October. So it should make sense that they're getting this information from before the termination, because stuff happened to cause the termination. Despite this offer, we understand you are unwilling to accept this proposal to further limit the scope of WFG's requests or propose a compromise of your own. You also raise specific objections to the temporal and topical scope of the interrogatory. We ask whether it would resolve your objections, at least in part, to limit this request to documentations and communications regarding WFG's future ability to stay in business, compensation structure, opportunities with WFG, dating back to 2023. So WFG is making concessions here. They're saying, okay, well, just give us the information that says about WFG staying in business and WFG's compensation structure and the opportunities. We can cut out the rest, right? We don't need happy birthday grandma. We don't need happy anniversary wife. We just want the stuff that's specific to us, and we're willing to narrow some of that down. Notwithstanding that offer, you were unwilling to agree to that modification, and you instead insisted that another meet and confer session would be necessary without offering explanation as to why. So again, oh, well, we need to talk more about this. Can we meet again and have another discussion about what exactly it is that you want? Additionally, despite our repeated requests for whether Mr. Olson, Ms. Olson, and GFI intend to stand on the objections, unilateral limitations, identified responses to WFG's discovery requests, you were unwilling to do so. So part of the manipulative part here is pretending like you're willing to concede some ground, right? So I come to you and I say, well, not these dates, how about these dates? And then you say, okay, that's fine, let's start with that. And then a week later, I still haven't given you what you asked for, and then I go, well, we should meet again. I think maybe instead of this, we cut it down to this, and then, well, maybe it's this, and you're going, no, that's not right. And then I go, okay, well, let me see what I can do. And then a week later, you still haven't gotten anything. Well, let me set up another meeting so that we can talk about this. And it's just to furtherance not giving up the information. So in order to move forward, we need confirmation by today. So WFG is starting to give some like harder deadlines, like we're tired of playing around. Give a, like, here's your deadlines. Are you willing to agree to this proposal this morning on this morning's call? So again, the funny part of GFI is they're not going, well, we're not going to give you any of this information. They're going, oh, well, maybe we could give you that. Let's talk more about it. And what WFG is saying, look, either give us the information that we've requested, or say that you're not going to give it to us, so then that way we can have the court come in and step here. Don't play this middle ground of, oh, well, let me see what we can find and let's get back together. Just give us a clear definition of what you want to do. They're saying that the court order was very clear. The judge told us exactly what we could get and what you were supposed to do. You were supposed to do it within 5 days and then process witnesses within 5 days following that production. Produce witnesses in 5 days. So 10 days total. And we have repeatedly stated that we are willing to work with you because we understand the practical realities of the documenting process, but you have been unwilling to commit to a time by which you anticipate producing the documents or confirm whether you would even be willing to withdraw or modify the limitation that you have posed on GFI's request. We look forward to your response. So you can see kind of the games that are being played back and forth here. So that one was from the 7th. Now these ones are out of order. This is the 15th. So we're going to scroll down. It's kind of interesting, the information that they've been able to gather so far. So you'll see some of the numbers and let me know if you think that that's kind of strange. So this is on the 8th. Okay. Please see attached correspondence regarding this morning. So they did another meeting, another conference call regarding this cover. Thank you. We look forward to receiving your response. And here's some data that they've collected. So Eileen, I think this is GFI's people responding to WFG. So thanks for your letter and call yesterday. This one's on the 10th, or sorry, on the 8th. Yeah, and so this is going to be from GFI to WFG. So thank you for your letter and call yesterday. We explained on our call we disagree with your position about the date range, but we believe that the issue is best addressed. We obtained the concrete data and hit counts after we have uploaded the relevant materials. We also noted that it would likely take longer than an arbitrary cutoff of 5 p.m. So we're not going to be able to meet your deadline. Sorry, we got to expand that. As explained yesterday, we have been collecting their data, their documentation without any screening as to obtain the complete universe of potentially responsive matters. Our collection includes all forms of communications, including emails, texts, other types of messaging, including signal chats. We are collecting from their phones, emails, and other cloud-based storages. We have been working as quickly and as we and the vendors can collect data, right? Because they have to work with a third party to be able to do this. So here's some interesting information on what they have collected. And this is back on the 8th. So we've collected over 350,000 emails from Eric and Sandra Olson. Also 75,000 of which are dated from September to the present. Does that seem like a lot to you guys, or is it just me? So we're talking 6.5 months, right? September, October, November, December, January, February, halfway through. No, this is the beginning of March. So maybe it's more like 6 months. 75,000 emails in 6 months. That's over 10,000 per month. I don't know. You guys let me know. Does that seem like a lot to you? And then on Sandra's phone alone, we have collected 47,000 text messages for the same time period. So from September to beginning of March, 47,000 text messages. The texts from Eric's phone have not been uploaded, but we expect this phone to have similar, if not higher volume than Sandra's phone. Now, I don't know, if you do a group text with 20 people in there, does that count as 20 different messages? I don't know exactly how that works. The Signal and Telegram messages have not been uploaded yet. The encryption associated with these apps has created some other delays. As we told you yesterday, Mr. Olson has a Google Drive associated with his email. That drive contains information from the operations of Pinnacle. Mr. Olson does not know how to access it personally, so he has a Google Drive he doesn't know how to access and has warranted that he won't access. So even if he could access, he's not going to. The drive consists of over 7 terabytes of data that is still in the collection process. We don't know what is on the drive, and we're working with our vendors to figure out to disable Mr. Olson's access without cutting off his ability and access to unrelated personal files on the Google Drive. Obviously, this material would be outside of the date range we believe is to be appropriate. We do not believe it is relevant, such as it is not accessed since he was wrongfully terminated. So again, they're saying, well, he hasn't accessed it since he was terminated, so we shouldn't have to give you any of that data, which I don't know how helpful that would be. 7 terabytes, that's a ton. Most computers are what, like 500 gigabytes? It's a half a terabyte. So that's like 14 computers worth of stuff that he's got on his Google Drive. I mean, I don't know. And so they're going to help meet and confer our efforts. We appreciate cooperation. In the process, though, we may disagree with some of the substance. So they're still supposedly collecting the data. Okay, so that was on the 8th, in accordance with that email. And here's also what they tailored. So this one is on the 13th. So you can see they still haven't gotten any data, but they're starting to tailor some of that information. They're trying to collect everything. So thanks for your email. We have been able, this is from GFI to WFG. We have been able to complete the process of Olson's phone as well as the Signal and Telegram messages on both Mr. and Mrs. Olson's phone. This added an additional 44,000 text messages and chat messages to our collection. That's from September to March, September through February, I guess would be more accurate. 44,000 text messages on his, 47,000 text messages on hers, 75,000 emails. That, I don't know, does that seem extensive to you? That seems like a whole lot. So this is what they're proposing to start limiting some of this data. Okay, so they say, here's what we'll search for. WFG, World Financial, worldfinancialgroup.com, which who would ever send that in a text message? I don't know. That's not going to produce anything, right? And then they say, we'll look for these particular people, you know, what did they say about these people? And then maybe what they also said about these people, we'll search for those guys, that specific information, and then these guys down here as well. So anything pertaining to these people, we'll add. And so with those search terms alone, it yielded more than 10,000 individual text messages, emails, and messages from other messaging apps, which our team is in the process of and reviewing. We have considered your date range proposal. We continue to view our date limitations as appropriate for at least 3 reasons. The events occurred before WFG's wrongful termination of Mr. Olson. So again, they're arguing we shouldn't have to give information over, we shouldn't have to give you this information because it was before the end of January when he actually got terminated. So for number 1, encrypted information. Where's number 2? First of all, is wrongfully or not conducted. WFG is seeking its merits and discovery. Oh, second, such discovery is not appropriate in the light of the court's order. We identify the basis for expedited discovery and its use of encrypted messaging service to rapidly unfold events, including the conference in early March. Those concerns are addressed by our collection, preservation, and production of encrypted messages, and the fact that the conference is in Hawaii and ongoing will have been ended before the respective motions. So again, they're just kind of arguing with what's going on. And it's kind of funny here, I think this last one. Third, in addition to falling outside of the scope of what should be allowed as expedited discovery, WFG's proposed date cutoff would impose a significant burden beyond what we are already incurring in providing the exhaustive expedited discovery set forth. So if you make us actually give you all the documents you want, it's going to add roughly 50% more work to us. And, you know, that's just really not fair. I'm sorry, that's funny to me. I probably shouldn't laugh. We are more than willing to meet and confer tomorrow or Thursday. Let's set up another meeting to talk about this. In the meantime, we will continue to make progress and review our intention to make our production this week, right? Keep putting it off. All right, so then on the 14th, thank you. Here's another time. Let's set up another conference call on the 14th. We've stated we'd be happy to meet and confer. We want to connect the timing of these things. Are you available at this? So they're just kind of scheduling. Oh, separately, a few days ago, we sent out an email trying to connect for depots for WFG agents, copying you on those, but we have not heard back from Gordon or Reese. I don't know who either of these guys are, if you guys know who Gordon or Reese are. We would like to discuss that tomorrow. 2, I assume you have been in communication with them. It would be great if you could get them involved and get that done as well. Because I think that was something that Olson was asking for. Unfortunately, we have a conflict at this time. Can we do another time? Okay, let's do 12:30. This is on the 15th. Okay, and we finished that section of emails. This is on the 15th. Thank you for your call earlier this afternoon. We write to follow up and summarize our meeting. We stated our previous letter dated on the 17th. They're kind of like making notes for all this stuff. So when they turn it over to the judge, that they're gonna have some relevance here. Like, look, we've worked with these guys. We've tried. They keep pushing us off, but none of them have produced any documents in response to this request. You have provided us with an update of your search productions, which we appreciate. However, we still have not been provided a concrete time frame. So GFI keeps saying, yeah, well, we're working on these things. We'll get it to you eventually. And then weeks go by and nothing's happening. So with respect to your search terms, we provided a list of updated terms that we would like. We understand your concern regarding GFI, as you think it may be overly burdensome, seeing that the term is used in at least one of the email addresses. So that could be kind of annoying, right? Because if GFI is in the email, so note if you don't want discovery, do your name at the company, whatever, at gmail.com or whatever, so that way it adds every single email you sent out, even the ones to grandma to say happy birthday, now get pulled up in this list of emails. So a way to avoid discovery there if you want to do that. With request to and I'm joking, by the way, okay? With respect to unilateral temporal limitations the defendant imposed in their discovery responses, we understand that we have reached an impasse. So we're not making any headway on this. We'll be seeking judicial intervention accordingly. So we're going to reach out to the judge and see if we can get some help, because you're not really helping us with that. So with respect to limitations on confidential information and responses to these things, you first stated that you were not in fact applying the limitation you identified and instead construed your own understanding of confidential information more broadly. However, you proceeded to state that you were applying your own interpretation of what constitutes confidential information. So they're making up their own definitions for things. According to this person, with respect to your request to further clarification regarding the scope of WFG's interrogatories, Mr. Olson, we clarified today that we are indeed seeking any communications that Ms. Olson had with customers regarding business or transfer of the business to GFI, right? This is important because this becomes churning. So did they go back to all of their clients and move them over into new policy? Now you can add stuff, that's perfectly fine, but to purposefully get them to cancel a policy and start a new policy, the client takes thousands of dollars in loss in that, in annuities and in permanent insurance policies. So that's bad for the clients. And this includes communication that Ms. Olson may have had with friends or family members. Yeah, so a lot of clients, we work with a lot of warm market in our industry, right? So that would include I have a lot of friends and family members who are clients of mine. And so she initiated life insurance policies with them, including her mom. So apparently her mom has a life insurance policy with her. My mom does as well. We are not interested nor seeking communications relating to purely personal matters. So yeah, you're right. We don't need the happy birthday, the happy Mother's Day, that kind of stuff. We don't need any of that. Merry Christmas. However, any communications with friends and family regarding Ms. Olson's business are still important. They're absolutely relevant to the current purposes of this litigation and must be produced. And GFI is saying, well, we can't give you all that information. And in the things that they defined, those key words that they want to use, you might not get something like that. You might not get those text messages in those particular requirements. So, or those particular guidelines that GFI is trying to assess on the production of information. We are similarly seeking communications regarding business or the transfer of business for anyone in Olson's hierarchy, to the extent that Ms. Olson is aware of such communications or possesses such communications in her custody and control. We do not expect her to solicit communication or documents from her agents in her hierarchy that she is not aware of or does not have in her custody or control. We understand that you will discuss this clarification with your client. So part of what they were saying on why they don't want to turn over these documents, they go, well, it's not fair. You can't ask the Olsons to go ask everybody else for their documentation, because it's in regards to the people that are close to them. And they're saying, well, that's not what we're asking for. We just want the communication that whatever she has. So if there's something between her and she sent a text message to this person, we should still be able to get that. We don't expect you to go get it from them. Just whatever's in your possession is what we want. And so we appreciate you discussing that clarification with your client. With respect to a protective order, we stated that we will agree to a protective order to the extent that it does not substantially stray from the model forms of the North District of California. We similarly stated that we will require the protective order to encapsulate existing or potential future related litigations, such as we can utilize any documents or communications to produce this litigation without having to repeat the discovery process or reproduce documents in each individual action. We really will agree to maintain any confidential or highly confidential designations preceded in this litigation in relevant litigations, and we have provided WFG's proposal to the draft protective order. So protective order, now they're trying to do additional documentation to say, well, we want to be even more limited on the information that we can get that WFG can get. We're going to all do protective orders, which I think they have filed at this point, to limit that information as well. So once you have had a chance to review, please let us know in further conference as necessary. So, okay, we'll do a protective order. And this could be kind of important, right? Because what if there's a social security number in there, or there's, I don't know, some kind of private information that they don't want to get out to the public. So WFG, again, is kind of conceding on this. They're saying, okay, as long as it doesn't limit our discovery, we will put a protective order on it that if there's anything in there that's confidential or highly confidential, that's produced related to this litigation, kind of think of, it's not quite classified documents, but kind of gets into that category of, okay, we'll be more sensitive with these things. But the question is, are they actually sensitive information, or are they just trying to elude giving information even further? So you stated that you will not produce any documents until the protective order is in place, and stated that this is a gating issue. So again, this is the 15th. So now, this is what, 10 days after they were supposed to produce this information. Now they're talking about a protective order. So it's been a week and a half. The discovery should be done at this point. And they're going, well, we think we need a protective order, and so we're not going to produce any documents now. Now that we've defined these things, now that we've limited the scope, now that we've done all those things, well, now that we think about it, we probably need a protective order, and we're going to do that first, right? So it's just delaying everything. So in regards to WFG's response to the defendant's discovery requests, which we are providing voluntarily, despite the fact that you have not requested leave or take early discovery, and the court has not authorized you to take early discovery in this matter, we confirm that we have drafted WFG's responses and are awaiting approval for the clients. Once the clients approves these responses, we will serve them on defendants. We anticipate that you will have these responses early next week. Finally, in regards to, I don't know if you guys know who these are, Jordan Altura or Gordon Reese. Are these WFG people maybe? I don't know, maybe part of the company. Because I think, excuse me, Olson asked for discovery around his temporary restraining order. So I don't know if those people are involved in that. If you know who that is, put it in the chat, please. We are aware that he has attempted to contact the third-party witnesses you have subpoenaed, and I've since responded to your email requesting a call discussing deposition scheduling. If any is scheduled, we would be happy to join. We look forward to receiving prompt response, and we hope to minimize the issues for which you seek judicial intervention. This was written by Ellen. All right. I think we're almost through it. So here's is this WFG's too? Yep. So this is WFG's proposal. They're saying, hey, we also need to add in these terms. If we're going to start limiting some of this stuff, we need to add in these terms as well, because that would be important to us. Thank you for this email. We're able to complete the processing. This added over, and this one I think, this one might have been part of that first one. Added another 44. Oh no, this is another one, right? This is from the 13th. When was this one? 15th. Okay, these are out of order. Again, apologize about that. But apparently those added another 44,000 emails or text messages included in that. And then this is a copy of the first one we just read. Exhibition M. This is on the 16th. Okay, so this is a new one we haven't gotten to yet. Thanks for your call again yesterday. However, we ensure our correspondence accurately reflects our call. First, regarding the timing of our production. So this is from GFI to WFG. Regarding the timing of our production, we were ready to produce documents yesterday as we said we would. Any delay is not due to a lack of diligence on our end. We flagged in our initial call due to the personally identified information potentially it would help if I didn't cross everything out, right? Competitive, sensitive information that our client is seeking, and the real risk of retaliation against our clients and others. We need to have a protective order in place before we can produce documents. So again, we were ready to give you everything, but now we realize that we need a protective order. And so we provided edits to the proposal to the order on the 7th. We have heard nothing from your client until roughly 6 p.m. last night. So we gave you some ideas on the proposal for that protective order on the 7th. It's now the 15th, and we still haven't heard anything on that. So you still haven't filed it. You also said WFG wanted us to run additional search terms. We said we would be glad to, but we were unprepared to say that those search terms would, until again roughly 6 o'clock last night. We will review your edits sent on the protective order and get back to you shortly. Secondly, with respect to your purported concerns with the confidential information, this does not accurately reflect our position. We still do not believe that we should have to turn this over to you. We disagree with that such information is confidential and in any legal sense, but have not restricted our review to our understanding or any recognized legal definition of confidential. Third, regarding your position of WFG's response to our discovery request are voluntary, we strongly disagree. Your client agreed to provide reciprocal discovery to avoid motion practice, asking the court to provide us the right to seek such discovery. That does not make your discovery response voluntary or optional in any sense. And to that end, we had understood that WFG would be providing responses to our discovery requests last week, but we learned on Friday that rather than abide by the 5-day timeline by which we proposed requests, WFG will get us responses early next week. We look forward to receiving your discovery responses. Fourth, please provide dates for these witnesses' production prior to the production. Fifth, as for communication with these people, as you know, they have not requested a call. Rather, they have refused any such call. So maybe both sides are kind of playing around here. We will follow up with them directly, but we keep we keep you copied. We would appreciate if you would do the same with your third-party discovery requests and scheduling. In that regard, it appears that WFG unilaterally scheduled a deposition for Mr. Valle without coordinating with us, required by the law. We will try to confirm that date with our team, including Ms. Olson's counsel. If it turns out that the date does not work, we will need to select an alternative date. So it sounds like WFG finally set a time with Mr. Valle to do his, but they haven't let them GFI know yet. So GFI is going to say, okay, well, we'll look in our calendar and we'll see if that works for us. And maybe it does, maybe it doesn't. Finally, thank you for sending the proposal of the search terms. We agreed to run the terms and follow up there if there are any are appropriate to include. And that's the end. So those are all the newest documents that have kind of been produced around all this stuff. So I don't know, you guys tell me, does it seem like everybody's just playing games here and we're not actually moving the ball forward? And I don't know, should WFG turn over information if GFI is not doing it? I don't know. It's supposed to be kind of a reciprocal thing. Either way, it sounds like they're at a standstill. And so now they're going to be talking to the judge, which is going to be happening again on the 27th. So if you want to join us for that, we're going to be doing that again. We cannot broadcast it. We cannot rebroadcast it, but we'll see if we can watch it live. Maybe we'll talk about some of the stuff that's going on. We'll just have to watch it on our phone separately and kind of see what's going on. Why are they at an impasse, and what is the judge going to do from that standpoint? So hope that was helpful for you guys. I appreciate you. And again, on Monday, we're going to be talking about what's going on with Cofield. His is fairly long as well. Apparently, he's been dodging all of these requests to serve him. So we'll see what's going on there. Hope that was helpful for you guys. I appreciate you. Catch you later. Bye.